side. Stop struggling against my demons. Stop taking life as fiction. Eddie, burn, burn, burn. Burn the pain, burn the lies, burn the fear inside myself, and burn it all again. It's the right time to escape this cage I've been locked in for so long. It's not where I belong. Let it burn, burn, burn into the ground.
Welcome to Burn After Reading. I'm your host, Rick. In Part 4, we'll delve into a detailed timeline of the post-conviction events surrounding Damien Echols, Jason Baldwin, and Jessie Misskelley. This timeline will explore how their case ignited a high-profile advocacy movement, revealing alternative suspects, questionable DNA evidence, and ultimately how persistent efforts and resources led to their release from prison. Before we begin, I'd like to address a separate incident that, while not directly crucial to the timeline, warrants mention. In 1995, Damien Echols alleged that he was raped by a fellow inmate, Mark Gardner, while incarcerated at the Tucker Maximum Security Unit. An investigation ensued, ultimately revealing that Echols' allegations were unfounded. Notably, both Echols and Gardner provided inconsistent accounts of the alleged incident, alternating between claims of multiple rapes and denials of any assault. With that additional context, let's proceed with the timeline. Grab a beverage, get comfortable, and let's dive in. March 29th, 1994. Attorneys for Damien Echols and Jason Baldwin filed a motion for new trial alleging misconduct by prosecutors and alleged threats made to jurors. April 6, 1994. Attorneys for Jason Baldwin filed a motion for recusal requesting that Judge Burnett recuse in this matter so an impartial court could determine whether or not the prosecution was guilty of misconduct. April 12, 1994. The state filed their response to motion for new trial. April 22, 1994. Judge Burnett issued an order denying the motion for recusal and the motion for mistrial. 1995. The book Blood of Innocence, the true story of multiple murder in West Memphis, Arkansas, was published by Mass Market, authored by Guy Reel, Mark Proesquia, and Bartholomew Sullivan. This true crime account recounts the brutal murders of 3 8-year-old boys and the trial of 3 local teenagers. Notably, the book provides a factual and balanced portrayal of the events, avoiding personal narratives that would be characterized in later books and documentaries. June 27, 1995. Damien Echols filed a pro se motion in which he stated that he waived all points for appeal which concern the sentence of death and desires to limit the appeal to those issues which concern the judgment of conviction. To clarify what a pro se motion is, it is a legal motion filed in court by a person representing themselves without the assistance of a lawyer, meaning they are arguing their case for themselves. July 17, 1995. The Arkansas Supreme Court remanded the matter for findings by Judge Burnett on the questions of whether Damien Echols fully appreciated his position and can make a rational choice with respect to pursuing or abandoning issues on appeal concerning his death sentence. December 6, 1995. Damien Echols filed a motion to withdraw his earlier request that the Arkansas Supreme Court not consider the death penalty issue on appeal. January 8, 1996. The Arkansas Supreme Court ruled that it will review every aspect of Damien Echols' case rather than only points of guilt or innocence. They also ruled that a competency hearing shall be conducted by Judge Burnett for the reason that the development of such a record will best protect the interests of the appellant and the state in future proceedings. February 19th, 1996. In a 32-page unanimous decision, the Arkansas Supreme Court upheld the conviction of Jessie Misskelley. March 11th, 1996. Damien Echols competency hearing. After statements by Echols' attorneys and brief testimony from Echols, Judge Burnett found that Damien Echols is competent and was competent during the course of his trial, and that he's voluntarily and knowingly and intelligently withdrawn his request to waive the punishment aspect of the previous trial. March 16th, 1996. Attorneys for Jessie Misskelley filed petition for rehearing in the Arkansas Supreme Court. March 29th, 1996. Melissa Byers, mother of Christopher Byers, died of undetermined causes. Melissa and John Mark Byers were having problems in their marriage in 1996. Melissa left her husband to live with her parents and only returned home for 2 to 3 weeks before she passed away. John Mark thought Melissa had overdosed on a drug. He was concerned that they were going to accuse him of smothering her. April 1st, 1996, the Arkansas Supreme Court denied Jessie Misskelley's petition for rehearing. June 10th, 1996. HBO released the documentary Paradise Lost: The Child Murders at Robin Hood Hills, which was directed by Joe Berlinger and Bruce Sonofsky. The film explored the triple murder of 3 8-year-old boys and the trials of 3 local teenagers, Damien Echols, Jason Baldwin, and Jessie Misskelley. The documentary featured Metallica's music, which MTV heavily promoted. The victims' families were not adequately prepared for the graphic content of the film. Without warning, the documentary showed police footage of the victims' naked, brutalized bodies, hogtied at the crime scene. The families felt exploited and misled, as the filmmakers had assured them that the documentary aimed to protect children. One of the directors, Joe Berlinger, stated in an interview with Grantland in January 2012 that from the first interviews with the West Memphis Three, it just didn't add up. Jason Baldwin was shy but very intelligent, credible, and believable about his innocence. He was also very slight, with tiny arms and small wrists, and the theory of him killing these young boys with a giant butcher knife seemed impossible to imagine. Berlinger said Echols was a little harder to read because some part of him was reveling in the attention. Damien didn't think he would actually be convicted. He was kind of an alienated, bored teenager who at some level was enjoying being in the spotlight of a terrible situation. Despite being harder to read, he too was very credible to Berlinger. The directors left those interviews thinking that something just didn't seem right. This became the narrative for the documentary. Their criteria were based on initial interviews with 3 manipulative teenagers, and moreover, most of the information they received came from the defense as they got to know them. This documentary would open Pandora's box, marking the start of the West Memphis Three innocence movement. October 7th, 1996. The U.S. Supreme Court denied Jessie Misskelley's petition for writ of certiorari, and to clarify what writ of certiorari is, it's a mouthful. It is a legal document that asks the Supreme Court to review a lower court's decision. The word certiorari comes from Latin and means to be more fully informed. December 1996. Michael Carson stands by testimony. In the Jonesboro Sun, a witness in the West Memphis triple murder said that Michael Carson committed perjury when he testified in 1994 that Jason Baldwin confessed to killing 3 8-year-old boys while the 2 were jailed. Carson, a then 16-year-old who testified that Baldwin described in detail how he sexually mutilated one of the 3 children killed in May 1993, told the Sun he stood by his testimony. Yes, Carson responded when asked if Baldwin had in fact confessed to him about killing the 3 boys, Michael Moore, Stevie Branch, and Christopher Byers. What I testify to is what Baldwin told me. I haven't changed anything. I told him exactly what he said. During oral arguments at an appeal hearing for Baldwin and Echols held several days ago, Angela Grinnell, Baldwin's mother, produced a letter from a Kentucky musician who claimed Carson told him he lied when he testified that Baldwin had confessed to taking part in the killings. Dated October 28th, the hand-printed letter addressed to Baldwin at Arkansas Varner Unit was a stationery that read, "Johnny Running Bear Preston, who is a distinctively unique harmonica stylist and also wrote songs." Preston related that he was in Jonesboro in either March or April 1994, and while passing the Forum in the downtown area, picked up a kid who later told me his name was Michael Carson. Carson said he never met Preston, nor has he ever had a conversation with the man. According to Preston's letter, Carson began asking questions about the penalty for perjury. When pressed for information about why Carson was concerned about perjury, Preston said the teenager told me about being in jail with Baldwin and he had what he called a bad conscience because he lied on a boy in court about some kids being killed around Memphis. He recalled something about the murders, Preston said. He said that Carson started crying and said Jason didn't tell me nothing, and that the only reason he lied was to get in good with the cops who wanted to nail him on a few things. Asked about the letter, Carson stressed, "That's just something somebody has made up. They're just trying to make me look bad so Baldwin can get off. I don't go around crying about things in front of total strangers." The letter further stated that Carson charged that Prosecutor Brent Davis of Jonesboro knew his testimony was false, but told him he couldn't be helped if he didn't help out with the state's case. Carson said that portion of the letter was also untrue, because he was not in trouble with the law at the time he testified, and did not need to work out a deal with the state. "I had nothing to gain by testifying," Carson said. "I had already gone to court for burglary and had already been given probation. I didn't testify to cut a deal with anyone." December 2nd, 1996. Oral arguments before the Arkansas Supreme Court. Attorneys for Damien Echols and Jason Baldwin asked the Arkansas Supreme Court to overturn the convictions. December 23rd, 1996. The Arkansas Supreme Court upheld the convictions of Damien Echols and Jason Baldwin in a unanimous vote, rejecting all 44 points of appeal. May 27th, 1997. The U.S. Supreme Court denied Damien Echols' petition for writ of certiorari. November 11th, 1997. Free the West Memphis Three at wm3.org is born. A small group of private individuals who strongly believed the three young men at the time was serving prison terms in Arkansas for a triple murder they did not commit created a website. In their belief, after much alleged research, that the justice system failed to provide the West Memphis Three with a fair trial, and it was their goal to collect their alleged facts and distribute the information to the public in an effort to confront the alleged injustice with their perception of the truth. Their goal was to publicize this so-called injustice to the world and provide information necessary for individuals to reach their own conclusions through advertising and media involvement. Donations made to the Free the West Memphis Three Fund were supposedly used for those purposes only. May 5th, 1998. Damien Echols' Rule 37 hearing began in Jonesboro, Arkansas. Also in this year, Damien Stidham recruited forensic criminologist and criminal profiler Brent Turvey to profile the murders of Stevie, Michael, and Christopher as a way to second-guess and counter Jessie's confessions, law enforcement's investigation, and the state medical examiner's conclusions. Turvey, working pro bono, examined photos of the bodies and other evidence and determined the following. There were search parties moving through the area which would not have given the assailants the time needed to carry out the attack without being disturbed. The nature of the injuries to Christopher Byers would have caused him to scream. No screaming was heard by searchers or local residents near the site, so it must have occurred somewhere else. There were no mosquito bites on any of the bodies, which would be expected if they had been in the woods for the period of time that would have been required to carry out the attack. Michael Moore had unexpected and unexplained directional pattern abrasions just below the right anterior shoulder area. This abrasion was created by forceful directional contact with something that was not found at the scene. The nature of the attack required light, time, and uninterrupted privacy. It was dark in the woods. The crime scene would more likely be a secluded structure or residence away from the immediate area of attention. The assailant was someone known and trusted by the victims. The physical evidence, crime scene, and victimology in this case are most consistent with the classification of a battered child or child custodial homicide. The fact that there were 3 children together suggests that it would have been difficult for the offender to take all 3 children unless he was able to gain their trust. The children would have been taken to another location before the attack began, which implies a level of trust. Also, the intimidation and fear would have been factors in gaining control, suggesting that the assailant was much larger and stronger than the victims. The violence and level of force in this attack was punitive in nature, indicating that the offender was punishing the boys for some real or perceived wrong. The difference in the nature of the injuries of the 3 boys indicates that the assailant had a different relationship with each of the boys. Michael Moore is described by Turvey as collateral victim, who probably only was attacked because he was with the other 2. The severity of the blows to the head and the lack of damage from the ligatures on his ankles and wrists suggest that he was unconscious throughout the attack. The anger of the assailant manifested in victim damage and sexual mutilation is directed primarily at Stephen and Christopher, indicating a strong personal association with them. That all of the related physical evidence was disposed of at the dump site suggests that the assailant believed he may be investigated because of his relationship to the victims, and so he had to dispose of any evidence. The dump site, being so close to the point of abduction, suggests that the assailant knew the area well and lived close by, to enable a quick return to an area of safety. He would also have to have been to the site recently to know that there would be water there at the time. He believes some of the wounds were bite marks. The type of bite marks are most often seen in battered child homicide. The presence of healed injuries on Christopher Byers' body, Melissa Byers' concern that Christopher was sexually abused, which she expressed to a school counselor before his death, medical records reported behavioral problems, and Chris's diagnosis with ADD and other behavioral disorders are all strong indicators that Christopher Byers had been physically, if not sexually, abused prior to the attack. Stephen Branch had lacerations on his penis, which were probably self-inflicted, indicating a sexualized child usually associated with sexual abuse. There were probably 2 assailants. The primary assailant would have been a man whose focus was directed towards Christopher Byers. His accomplice may have been a male or female. 3 victims would have been easier to control if there were 2 attackers. The nature and range of injuries to Stephen and Christopher indicate 2 separate assailants with very different ways of expressing their rage. The battered child nature of the bite marks on Stephen Branch is more often associated with a female offender. The attack on Stephen Branch was more punitive in nature than sexual. The suck mark bite marks on Christopher Byers are more sexually oriented. The attack on his genitals suggests an offender who is ashamed of his own sexuality, possibly confused and angered by his own sexual impulses towards males. The offender was punishing Christopher for his sexuality and to establish or re-establish sexual ownership of him. The primary offender in these murders is described by Brent Turvey as possibly having the following characteristics: showing violent and selfish sexual behaviors, a very selfish and explosive individual with potentially violent temper, wants to be perceived as not caring how others view him, would be described as hostile, angry, and someone who carries grudges, would project a macho, heterosexual, and control image, an egocentric individual who cannot tolerate the criticism or shortcomings of others, requires instant gratification for his impulses and can react violently when those impulses are not satisfied. He may be glib and superficial and extremely manipulative. Dominant in all relationships with women. Very possessive and irrationally jealous in his sexual relationships, possibly manifesting in violent behavior acted out towards the females in his life. Would have a level of knowledge and sophistication in criminal activity through repeated offenses, exposure to law enforcement training and techniques, or previous arrests for similar crimes. May have spent some time in prison or commits petty crimes to support himself. Probably will have past arrests for drugs, violent behavior, and assault. Very likely to have been married more than once. A misogynistic attitude toward women, and past relationships would have involved a great deal of physical and or emotional abuse. If married at the time of the offense, the marriage would have been in crisis. His wife may have been the compliant partner in this crime. It is very likely that the offender would have been involved in the search for the boys, possibly dumping the bodies with the intent of being the one to find them in order to shift blame. Offender will probably have a collection of knives and will possibly have a similar interest in firearms and guns. Will probably have a drinking problem or a drug habit supported by criminal activity. He is probably unemployed, unable to hold down a full-time job for a number of behavioral reasons. He probably used his own vehicle in this attack, which would most likely be masculine, like a truck. It should be noted that Brent Turvey's assessment should be taken with heavy skepticism. Knowing what we know now, it appears that he was custom profiling the offender as John Mark Byers and quite possibly Melissa Byers. Former FBI profiler Greg O. McCrary characterized Turvey as a self-proclaimed profiler, which adds to the scrutiny we should put on his profile, which reeks of assumptions. McCrary wrote in his book, The Unknown Darkness, Profiling the Predators Among Us, that not only has Turvey never completed any recognized training programs, as a matter of fact, he has never even completed even a basic policy academy training program anywhere. He had, however, authored a flawed textbook on profiling. The theory that the boys were killed elsewhere doesn't add up. Multiple witnesses saw them entering Robin Hood Hills on the day they disappeared, and their clothes and bikes were found at the crime scene. It is illogical to assume that the killer or killers would abduct the three boys from the woods, kill them elsewhere, and return their bodies, bikes, and clothing to the original location where it was being heavily searched. Given the evidence, it's reasonable to conclude that the boys were murdered in Robin Hood Hills. The explanation requires no elaborate leaps or assumptions. The fact that their bodies, clothes, and bikes were all found in the same location suggests a straightforward and logical conclusion. As Occam's razor dictates, the simplest explanation is often the correct one. Proponents of the dump site theory claim it would have been too dark to kill the boys in the woods at that time. However, this is incorrect. According to sunrise and sunset times, the sun didn't start setting until 7:50 p.m. in West Memphis. If the boys entered the woods around 6:30 p.m., there would have been over an hour of daylight left. The claim about it being too dark is unfounded. The boys could have been killed or incapacitated after 7 or 8 p.m., and there still would have been some light for the killers to dispose of evidence. Also, the noise from the interstate would have drowned out Christopher's screams, making it more than likely that no one would have paid attention to it with the mixture of noises from traffic. Another aspect of the dump site claim is the absence of mosquito bites on the bodies. The defense argued that this meant the boys couldn't have been murdered in the woods, and Brett Turvey echoed this. However, this claim is misleading and unproven. Mosquito bites require time to develop visible inflammatory reaction. The absence of visible blood at the crime scene does not necessarily mean that there wasn't any there. Luminol tests revealed the presence of blood in multiple locations within Robin Hood Hills, including the ditch banks near where the bodies were found. Some areas showed signs of large amount of blood. Although luminol evidence was inadmissible in court at the time, it was shortly admissible after, and it still is today. The defense emphasized the lack of visible blood, but this overlooks the luminol findings. If the woods were merely a drop-off site, there would be no need to clean up multiple areas of the ditch bank. The presence of cleaned up areas suggests that something occurred at the scene. The killers allegedly tried to wash down the ditch banks, using water, sticks, and leaves to scrub and scrape away evidence, possibly including blood. Detective Brian Ridge testified that it appeared someone had cleaned off one of the ditch banks, attempting to wash away evidence. The scrubbing and washing of the ditch banks corroborate the presence of blood, supporting the conclusion that a crime occurred at the scene. March 19th, 1999. After 8 days of hearings between May 5th and this date, Damien Echols' Rule 37 hearing came to an end. Under the law, Judge Burnett had 90 days to rule. June 17th, 1999, Judge Burnett issued an order denying Damien Echols' Rule 37 petition. To clarify what a Rule 37 is, it is a rule of a criminal procedure that governs post-conviction proceedings and relief. It also covers petitions based on claims of ineffective assistance of counsel. December 3rd, 1999. Damien Echols married West Memphis Three advocate Lori Davis. After watching Paradise Lost, New Yorker Lori Davis wrote to Echols in April of '96. By the end of July, she flew down to visit him. She felt by then that Damien and the case were her future. In 1998, Davis left New York and landed in Little Rock, and on December 3rd, they got married in a Buddhist ceremony on prison grounds in front of 6 friends and witnesses. From that point on, Lori would become Damien's handler and spearheaded the campaign, raising funds and working closely with celebrity advocates who could bring attention to the case like Johnny Depp. She also recruited attorneys like Stephen Braga, who agreed to work the case pro bono. June 22nd, 2000. HBO released Paradise Lost 2: Revelations, although some sources suggest that it may have been released as early as March of that year. The sequel revisits the case of the West Memphis Three, who were convicted of a triple child murder in 1994. The film raises questions about the evidence and suggests that the community prejudice led to a miscarriage of justice. The documentary profiles the grassroots movement to exonerate the three and features John Mark Byers, the father of one of the victims. Byers asserts the three's guilt, but the film casts suspicion on him, fueling widespread speculation that suggests he is the real killer. February 27th, 2001. Attorneys for Damien Echols filed a petition in the Arkansas Supreme Court seeking to have the court reinvest jurisdiction in the circuit court for purposes of considering a petition for writ of error norum cobis. The norum cobis petition raised 3 issues. 1. Whether Damien Echols was competent at the time of trial. 2. Whether he was improperly administered psychoactive medication during trial. And 3. Whether the state concealed exculpatory evidence. March 9th, 2001. Attorneys for Jason Baldwin filed a motion to preserve evidence and for access to evidence for testing. March 15th, 2001. Oral arguments before the justices of the Arkansas Supreme Court. Summary. Edward Mallett, representing Echols, argued that Echols' trial attorneys Val Price and Scott Davidson were so involved in discussions with filmmakers before and during the trial that Echols' defense was compromised because the contract negotiations helped shape defense strategy. Mallett discontinued the defense attorney's assertions that they enlisted the filmmakers to help finance the defense. He said the attorneys should have asked the court for money to hire appropriate experts and would have expected the state to pay for it. Instead, Price and Davidson wanted to become famous, and movies made lawyers famous, Mallett said. It was about money, he said. It was about the consequences of making a movie. If the attorneys had not been worried about the film deadlines, they would have asked for a continuance in Echols' trial since it began soon after Misskelley's trial, Mallett added. David Raup, a senior assistant attorney general, told the High Court that testimony at a circuit court hearing on effectiveness of the attorney showed that the contract benefited the defense. Not only did the defense get money, about $7,500, but it also got the benefit of a documentary record that they could review as part of their strategy, he said. Mallett also argued that the circuit judge, David Burnett, should have issued a more detailed order denying Echols' request for a new trial based on the ineffectiveness of his lawyers. Burnett's order only tallied 6 pages despite 8 days of testimony over several months and over 1,400 pages of transcripts and other documents. It's a very large and complicated record with many issues, Mallett said. But Raup noted that the case has been ongoing since 1993. To send the case back to Burnett to issue a more detailed order would do gross injustice to the issue of finality, he said. April 26, 2001. The Arkansas Supreme Court ruled on Judge Burnett's order in which he denied Echols' Rule 37 petition. They affirmed part of the order and remand in part with orders to Judge Burnett to make specific written findings on each issues raised by Echols. May 11, 2001. The state filed a petition for rehearing of the Arkansas Supreme Court's April 26 ruling. June 7, 2001. The Arkansas Supreme Court denied the state's request for a rehearing of the court's April 26 ruling. July 30, 2001. Judge David Burnett issued an order in which he entered further findings denying Damien Echols' Rule 37 petition. February 2, 2002. The state filed a response to Jason Baldwin's response to motion to preserve evidence. July 25, 2002. Attorneys for Damien Echols filed a motion for forensic DNA testing. September 5, 2002. Attorneys for Damien Echols filed a motion for stay of proceedings pending outcome of DNA petition. September 12, 2002. The Arkansas Supreme Court granted Echols a 60-day stay of proceedings. October 8, 2002. Maura Leverett, a journalist and advocate for the West Memphis Three, wrote the book Devil's Knot, the true story of the West Memphis Three. According to Leverett, in 1993, following the murders of 3 8-year-old boys, West Memphis police seemed baffled. However, detectives suddenly charged 3 teenagers, alleged members of a satanic cult, with the killings. Despite numerous investigative blunders, a flawed confession, and lack of physical evidence, the teenagers were convicted amidst a witch hunt atmosphere. Leverett's book implied that John Mark Byers might be the actual killer. However, it also contained factual errors, such as incorrectly identifying John Vogelman as a juvenile judge. November 7, 2002. Attorneys for Damien Echols filed a motion for a 90-day extension of stay of proceedings. November 14, 2002. The Arkansas Supreme Court granted Echols' motion for 90-day extension of stay of proceedings. February 20, 2003. Attorneys for Damien Echols filed a motion for 90-day extension of stay of proceedings. February 28, 2003. The Arkansas Supreme Court granted Echols' motion for a 90-day extension of stay of proceedings. May 28, 2003. Attorneys for Damien Echols file a motion to extend stay of proceedings until completion of agreed forensic DNA testing. June 19, 2003. The Arkansas Supreme Court granted Echols' motion to extend the stay, but declined, however, to issue an open-ended stay as Appellant Echols requested. Instead, they will grant further stay for a period of 70 days from the date of this opinion. October 2nd, 2003. Oral arguments before the Justices of the Arkansas Supreme Court. October 16th, 2003. The Arkansas Supreme Court denied Damien Echols' petition to reinvest jurisdiction in the Circuit Court to allow him to seek a writ of area coram nobis. To clarify what a writ of area coram nobis is, it is a legal procedure that allows a court to review and potentially overturn its own previous judgment if a significant error of fact was discovered that was not known at the time of the original trial, and which, if presented, would have likely changed the outcome of the case. Essentially, it's a request to correct a fundamental mistake before us, as coram nobis translate into Latin, that could lead to a miscarriage of justice. October 30th, 2003. The Arkansas Supreme Court affirmed Judge Burnett's previous denial of Damien Echols' Rule 37 petition. Attorneys for Damien Echols filed a petition for rehearing of the Arkansas Supreme Court's October 16th ruling. November 13th, 2003. The Arkansas Supreme Court denied Damien Echols' petition for rehearing of the court's October 16th ruling. November 14th, 2003. Attorneys for Damien Echols filed a petition for rehearing of the Arkansas Supreme Court's October 30th ruling. December 11th, 2003, the Arkansas Supreme Court denied Damien Echols' petition for rehearing of the court's October 30th ruling. June 2nd, 2004. Judge Burnett issued an order for DNA testing. Attorneys for all three defendants file a joint status memorandum in order to report to the court on recent developments. October 28th, 2004. Attorneys for Damien Echols filed a petition for a writ of habeas corpus. To clarify what a writ of habeas corpus is, it is a court order that requires law enforcement to produce a prisoner and explain why they are being held. The term comes from Latin and means "you have the body." Additionally, they also file a motion to recall the mandate and to reinvest jurisdiction in the trial to consider a petition for writ of error, as well as a memorandum in support of motion to recall the mandate and to reinvest jurisdiction in the trial court. To clarify what a motion to recall the mandate means, it is a request to overturn a court's final decision. The motion must be served on the opposing counsel, and they may file an objection. If the motion is granted, the party who requested the recall must pay any cost incurred after the mandate was filed. October 29th, 2004. West Memphis Three defense team won't be able to exclude any of the defendants. In a Daily Journal article posted in the WM3.org website, it reported something very interesting. Unlike the quintessential rape case, in which DNA results could conclusively rule out all but one suspect, defense attorneys acknowledged that the West Memphis Three can't count on lab testing to show they were absent from the murder scene. Read that again. The defense attorneys acknowledged that the West Memphis Three can't count on lab testing to show that they were absent from the crime scene. But they might be able to show that a fourth person, somebody with no ties to Echols, perhaps a known criminal whose DNA profile had been entered into a government database, left behind indisputable evidence that he or she had a hand in the slayings. Blake Hendricks of Little Rock, Arkansas, who served as local counsel for senior strategist John Phillipsborn, helping the West Memphis Three defense team, stated that they're not going to be able to exclude any of the defendants. They're trying to offensively include someone in there. After initial resistance to testing, Brent Davis has cooperated, saying he felt obliged to give inmates access to the best technology available to challenge their convictions. But he vowed that the defense lawyers will have a fight on their hands if they read too much into the lab results and draw unwarranted conclusions. I mean, the defense would never do such a thing, right? Later on, you'll see that's exactly what they did. Brent Davis's firm belief is that the results are not going to lead to anything beneficial to the defendants because they got the correct result the first time. Brent Davis also said it's been a challenge just keeping up with all the comings and goings of the defense attorneys. Unfortunately, it's 8 against 1 now, and the numbers seem to get lopsided as they go. Any disputes over DNA testing would be refereed by Circuit Court Judge David Burnett, who presided over the trial of Echols and Baldwin. Another issue predicted to come up is who should pay DNA testing expenses that could easily run to 6 figures. Arkansas statute is silent on whether taxpayers or defendants are supposed to pay. The West Memphis Three fronted the expenses from their legal defense fund, but it was assumed they'd request reimbursement from the state. So what does it mean when they say they can't exclude the West Memphis Three? Well, in later lab results, 29 items had no results, meaning they couldn't include or exclude anyone. 4 items couldn't exclude any male, 5 other items that couldn't exclude anyone, and the other 21 items exclude the West Memphis Three because those items only matched the victims. 38 out of the 59 items tested technically cannot exclude the West Memphis Three. When it comes to the ligatures, lab results found mixtures. One of the ligatures used to tie up Stevie Branch showed results for a mixture. The swab from Michael Moore's private area suggests a possible mixture. The swab from Stevie Branch's private area suggests there was something foreign there, and it didn't match either the West Memphis Three or the victims. However, there is an explanation for this. When autopsy photos were taken, one of the bare hands of a physician touched the private area of Stevie Branch. That is most likely what it is. Now, here is a look at both the victims and the defendants' locus chart. For those curious what a locus chart is, it is a visual representation of a locus, which in genetics means the specific location of a gene on a chromosome. Essentially, a locus chart displays the position of different genes along chromosomes, often used to analyze genetic variations and relationships between genes with a specific region. So Damien Echols, his numbers are 11 and 12. So are Jessie Misskelley's. Jason Baldwin is 9 and 9. Michael Moore is 9 and 13. Stevie Branch is 10 and 12. And Christopher Byers shares Damien Echols and Misskelley's number of 11 and 12. And from the information shown here pertaining to the Stevie Branch combined ligature, the results on that locus are 10, 11, and 12. The results are in the 5th column. Now, here there should only be 2 numbers, but instead there's 3. This means for that locus, alleles could be present from Echols, Branch, Misskelley, and or Byers. Now, on Michael Moore's penile swab, the numbers are 9, 12, and 13. The results are found in the 2nd column. And again, there should only be 2 numbers. All parties have either 9, 12, or 13 on this locus, so no one can be excluded. December 13th, 2004. The state filed their response to motion to recall the mandate. December 20th, 2004. Attorneys for Damien Echols file a reply in support of motion to recall the mandate. January 20th, 2005. The Arkansas Supreme Court denied Damien Echols' motion to recall the mandate. February 7th, 2005. Attorneys for Damien Echols filed a petition for rehearing regarding the Arkansas Supreme Court's denial of his motion to recall the mandate. February 14th, 2005. The state filed a response to Echols' petition for rehearing. February 24th, 2005. The Arkansas Supreme Court denied Damien Echols' petition for rehearing. February 25th, 2005. Attorneys for Damien Echols filed a first amended petition for writ of habeas corpus. March 2nd, 2005. The state filed a motion to dismiss petition for writ of habeas corpus for non-exhaustion. April 28, 2005. Attorneys for Damien Echols file response to motion to dismiss amended petition for writ of habeas corpus. May 13, 2005. The state filed a reply to Echols' response to motion to dismiss petition for habeas corpus. August 18, 2005. William R. Wilson, Jr., U.S. District Judge for the Eastern District of Arkansas, issued an order denying the state's motion to dismiss Echols' petition for habeas corpus. May 19, 2007. Remember when I mentioned there might be credibility to Ron Lack's strong-arming and intimidating people? Terry Hobbs met with Ron Lack along with Rachel Geiser. Here is part of that conversation.
There was a hair found in the ligatures that tied Michael Moore. Yes, she was. That they have identified it. We are asking everybody that's involved to submit to DNA sample that we got wrong.
Yeah, I would want to talk to Brent about anything, but I even if he said do it, I'm not opposed to that. I ain't got nothing to hide.
Well, the attorneys that we are working for have asked, they asked us to talk with you. And they want you to talk to this other guy, Rick Berry.
Rick Berry?
He's another person. Yeah, Bob.
Who's Rick Berry?
He works for us out of our national office. But he was a former homicide detective. Neat paper.
He's
here. You're about to meet him.
And do you think that I should talk to Brent before this? Because, I know what's behind this and what's motivating this. I don't know if I have any interest with Rick or not.
Well, the DNA that was found on that hair doesn't match Damien or Jessie. And doesn't match Michael or Stevie or Chris.
Mm-hmm.
So it's somebody else's.
You don't know whose? Elvis? No.
Yes, it is.
So, okay. Knowing that and hearing that, that would put me on the suspect list. I don't see how.
That's what we want to eliminate.
Eliminate. I'm not worried about DNA, but I sure don't understand how that would happen.
I don't either. We just received the results back. They got them back day before yesterday. They just called us with them yesterday morning.
And I spoke with Rick, who was Tuesday West this past week, and I asked him about the evidence that come back. He mentioned it.
Yeah.
So when would he know?
Probably the first.
Well, that still doesn't bother me.
Yeah, we wanted to take your
The problem is, Terry, we know that when this does come out, it's going to turn your life even more upside down. You know it.
You might think that. I don't agree with that. Especially because I know my innocence.
It's essential to correct a common misconception. Terry Hobbs was under no obligation to cooperate with or assist the defense attorney's efforts to exonerate their clients. This case is considered closed. Furthermore, this supposed startling evidence is insufficient, as you'll discover later. Also, Terry Hobbs, along with other family members, submitted hair samples, as you can see in this January 17, 1994 letter from the State Crime Lab. It's also worth noting that Ron Lack employed a similar tactic with David Jacoby. According to an interview conducted by West Memphis Three Facts on Facebook and two other researchers, Jacoby recounted that Lax and Rachel informed him that his own hair was a match for a hair found on a tree stump at the crime scene. Jacoby further described Lax's questionable methods, including being handed an envelope containing photos or documents, presumably of the murdered children, and being told to examine its contents. As a matter of fact, Ron Lax told him to look at his handiwork, implying his involvement in the murders. This tactic appeared to serve a dual purpose: to coerce Jacoby into cooperating and to persuade him into implicating Terry Hobbs. June 21st, 2007. Terry Hobbs voluntarily met with detectives Lieutenant Ken Mitchell and Chuck Knowles at the West Memphis Police Department and gave an interview. Terry Hobbs then and now is not considered a suspect. At least 40 articles published between July 2007 and November 2007 specifically mentioned that the hair at the crime scene either matched or potentially belonged to Terry Hobbs. When most hear the word DNA, they assume that means something like blood or semen. This DNA is actually a hair fragment found on a shoestring used to hogtie Michael Moore. This DNA does not match Terry Hobbs, but rather cannot rule him out as a potential source. Same with the David Jacoby hair. Not understanding the forensic science, the West Memphis Three supporters believed Terry Hobbs must have murdered the children, either on his own or with help. In truth, there were countless hairs. DNA testing couldn't even match some of the evidence at the scene to the victims, despite that they had to have been the source of some of it. Sadly, water had washed away and damaged any viable DNA needed to match the offenders, and this is through a process called hydrolysis, where the water molecules can break down the chemical bonds within the DNA molecule, leading to degradation and potential loss of genetic information. And this is especially significant when DNA is exposed to water for extended periods, particularly in situations where the water is contaminated or has extreme temperatures. And if you have seen the pictures of that dirty ditch bank in the water, that water is definitely contaminated, especially with the kind of junk that was inside it. October 29th, 2007. Attorneys for Damien Echols filed a Second Amendment petition for writ of habeas corpus. The attorney for convicted killer Damien Echols said DNA evidence proved he is innocent and he's demanding a new trial. Forensic expert Vincent DeMaio and Memphis attorney Gerald Scan walked into the office of a private investigator, and soon after, Pam Hobbs, mother of Stevie Branch, and John Mark Byers, stepfather of Christopher Byers, walked in through a side door. They were told of new evidence that pointed to Pam's ex-husband, Terry Hobbs, as the killer. November 1st, 2007. Damien Echols' legal defense team held a press conference. Dennis Reardon, lead counsel, introduced the Damien Echols defense team, including Gerald Scan and Deborah Stallings. The team discussed the federal habeas corpus petition, Echols v. Norris, which aimed to prove that Damien Echols' 1994 trial was unfair. The petition alleged that Echols' state trial did not adhere to the Federal Bill of Rights. Reardon explained that the case was not about guilt or innocence, but about whether Echols received a fair trial. However, due to an exception in federal habeas corpus law, the court could consider evidence of actual innocence. The defense team presented new evidence, including expert testimony from Werner Spitz, a renowned forensic pathologist, Richard Sevron, a forensic odontologist who testified against Ted Bundy, Tom Fedor, a DNA expert, and John Douglas, former head of the FBI's Criminal Analysis Unit. The team aimed to prove that no reasonable juror would convict Damien Echols based on the new evidence. The conference would provide context about the case leading to the arrest and conviction of Damien Echols. The team would present their expert findings and then open the floor for questions and answers. In 2005, the Bode Lab issued a report showing DNA profiles from the crime scene. Later, the lab analyzed DNA samples from the victims and defendants, but found no link between the defendants and the crime scene. A hair found on a ligature used to tie up Michael Moore was associated with Terry Hobbs, Stevie Branch's stepfather. Another hair found on a tree stump at the crime scene was associated with David Jacoby, a friend of Terry Hobbs. Thomas Fedor, a forensic serologist, analyzed the DNA samples and presented his findings. The DNA from the cigarette butt thought to have been smoked by Terry Hobbs did not exclude him as the source of the hair on the ligature. Approximately 0.12% of the population could be the source of the cigarette butt DNA. Approximately 1.5% of the population could be the source of the hair on the ligature. None of the defendants' DNA matched the hair on the ligature. Fedor also analyzed DNA samples from David Jacoby and found the DNA from the cigarette butt thought to have been smoked by Jacoby matched his cheek swab DNA. The DNA results did not exclude Jacoby as the source of the hair on the tree stump. Approximately 3% of the population could be the source of the cigarette butt DNA. Approximately 7% of the population could be the source of the hair on the tree stump. Fedor concluded that none of the defendants' DNA matched the hairs on the tree stump or the ligature, while the DNA of Terry Hobbs and David Jacoby could be associated with the hairs. With all that said, it's vital to point out what Thomas Fedor said later in the Q&A session of this press conference.
Why we're so much focused on Terry Hobbs? Is there really significant enough DNA evidence that can point to Terry Hobbs? Especially when the fact that the hair of the shoestring could come from inside the house. There's been a lot of talk about. I'm just stressing some of the things I've heard from folks in the region. We're familiar with the story. Is this evidence enough to say Terry Hobbs could have really done this?
The two hairs that I know about, the one that could in fact come from Hobbs and the other one that could in fact have come from Jessie, constitute what I call lead evidence. Because there are other people it could have come from, and there isn't any way to improve our selection of possible sources from that hair. I don't think, my personal opinion is, I don't think that hair evidence would be enough to convict Mr. Hobbs or Mr. Philby or anybody in a similar. It's really not strong. The percentages that I gave, people who could be the source of those hairs, are 1.5% of the population with respect to one hair, 7% with respect to another hair. That's not particularly strong evidence, and especially in the context of what most people are accustomed to. That's not these are considerably weaker than what we'll call an STR DNA test. Well, that virtually provides that hair.
In addition, he stated that secondary transfer could not be ruled out with the hair tied into the ligature because all three boys interacted with each other and had been to the Hobbs residence. Even though we know it was from a ligature used to tie up Michael Moore, we don't know whose shoestring that belonged to. Despite this hair fragment that may or may not belong to Terry Hobbs being an obvious red herring, the West Memphis Three propaganda machine promoted it to the media and its supporters as a smoking gun. Doctors Werner Spitz and Richard Sevron presented their findings on the injuries sustained by the three victims. Dr. Spitz, a forensic pathologist, analyzed hundreds of autopsy and crime scene photographs, concluded that the injuries on the victims were caused by animals after death, found no evidence of sharp force injuries or knife wounds, stated that the injuries were consistent with animal bites and claw marks. Dr. Sevron, a forensic odontologist, specializes in bite mark identification and has experience with animal bites, concluded that the bite marks on the victims were caused by animals, not humans, stated that the injuries were post-mortem and consistent with animal predation, criticized the prosecution's claim that a serrated knife caused the injuries, calling it ridiculous and unconscionable. Both experts presented photographic evidence to support their conclusions, including images of the victim's injuries, which they claimed were consistent with animal bites and claw marks, a photo of a knife allegedly used in the crime, which Dr. Sevron claimed could not have caused the injuries, but rather an alligator turtle. The experts' findings contradict the prosecution's theory that the victims were murdered by Damien Echols, Jason Baldwin, and Jessie Misskelley using a serrated knife. The state would eventually refute the animal predation claims. Dr. Frank Peretti, the state forensic expert at the original trials in '94, was roundly criticized by defense experts who pushed both the human bite mark and animal predation theories. But here's the thing. Peretti was an expert on turtles. As a matter of fact, he raised them. Dr. Peretti felt the shifting theories among the defense experts had little merit and vindicated his original findings. Peretti was asked by the state to review the testimony given by the defense experts Spitz, Baden, Sevron, and Offhoven. He said he only read parts of Spitz, all of Baden, and some of Sevron. He said he couldn't read much because the defense experts' opinions were ridiculous. He was pressed by Burt, became irritated, and then stated angrily that Spitz was incoherent, Baden reasonable, and Sevron out in left field. He said Spitz's description of a dog shaking the body, smacking them against trees, did not make sense. He went further and said that he felt their testimony was nothing more than a personal attack against him to make him look incompetent. He said only Baden said that the autopsies conducted were fine. He said he didn't think their opinions meant much because they had not looked at the actual bodies. He said he didn't feel badly for not supplying the information the experts asked for because he had asked for photos and other materials from them and did not receive anything. He went further and said that he felt important being attacked by all these experts. He said he was the only one who was right. Why did they need so many to prove he was wrong? Dr. Frank Peretti thought that the defense's animal predation claims were ridiculous because they had only observed the photographs of the injuries and they had not examined the bodies in person concerning Christopher Byers' injuries. Dr. Peretti said there were multiple wounds in the inner thighs. Here's his direct words. In my view, all the wounds occurred prior to death. Though I wrote that the wounds looked post-mortem, you could see hemorrhage in the tissues. There were some injuries to the buttocks and what I described as superficial cutting wounds and parallel lines. There was some drying of the tissues. I don't know any kind of animal that would have caused this kind of pattern of wounds. There were ghost cells found on the penis slides. These indicated the leaching of blood. The serrated knife that you have here could not have inflicted the pattern wounds on the skin. I found that the knife shown to me by the state had patterns consistent with linear gouges on the remains of Mr. Byers. Dr. William Q. Sterner, the chief medical examiner at the time of the autopsies, and I personally examined the bodies of the three boys along with Dr. Kevin Dugan, a forensic dentist. Dr. Dugan's findings that none of the wounds appeared to be human bite marks was corroborated by Dr. Harry Mincer. Second, as part of the autopsy process, tissue samples were taken from one of the superficial and penetrating wounds. When examined grossly and microscopically, these samples demonstrated presence of hemorrhage, clearly indicative of ante-mortem injury and not post-mortem animal activity. Third, physical examination of the penetrating wounds showed a lack of soft tissue bridging typical of wounds caused by tearing or biting. These wounds did not show clearly incised edges indicating they were caused by a sharp instrument. Finally, I have consulted with Dr. Charles Cox, the current chief medical examiner, regarding the autopsies, and he concurs in the findings made and the conclusions drawn from them. John Douglas, a profiler, discussed his involvement in the West Memphis Three case starting in 1993. He and his colleagues provided advice on neighborhood investigations and warned against using Satanism as a motive due to lack of forensic evidence. Douglas mentioned his research on sexual homicide patterns, motives, and violent crime studies, which led to the publication of the Crime Classification Manual. He found no evidence of satanic crimes despite examining hundreds of cases. Douglas expressed interest in re-examining the West Memphis Three case. Relying solely on facts and information, he interviewed new suspects and concluded that the case was not satanic or ritualistic. The killer knew the victims and lived nearby. The crime scene showed criminal sophistication. The killer's initial intent was not to murder but to taunt and punish. Douglas implicated Terry Hobbs and David Jacoby as potential suspects, citing their suspicious behavior and lack of cooperation with law enforcement. John Douglas classified the West Memphis Three case as a personal cause homicide, indicating the killer knew the victims well and didn't act alone. He believed the initial intent was to taunt and punish rather than murder. Douglas noted criminal sophistication at the crime scene, including tying wrists to ankles. The killer's concentrated effort to hide evidence, including clothing and bicycles. The killer's attempt to delay identification by hiding the victims in the bayou. He concluded the killer was criminally sophisticated and violent. The killer had no remorse and was likely a psychopathic personality. The crime was not satanic or ritualistic. Douglas also mentioned his interviews with Terry Hobbs, finding him credible initially, but later discovering that he was lying. He again implicated Hobbs and David Jacoby as potential suspects. But can Douglas's profiling assessment be trusted? He has actually been responsible for a couple wrongful convictions based on his casework. One he admitted to and rectified, the other he refused to accept that he was wrong. Let's get into his profile of Guy Paul Moran, a man convicted, then exonerated of the 1984 murder of 9-year-old Christine Jessup in Ontario. Douglas had done a psychological profile of the killer. When police arrested Guy Paul for the crime, the FBI man claimed this was a success. However, DNA tests on semen found on the victim's underwear exonerated him, who had served 18 months in prison. In Douglas's book, Journey into Darkness, he wrote that the DNA evidence might be a red herring, and that it could be a tragic instance when truth and justice will always be elusive. This alone is enough to throw doubt on any of John Douglas's profiles, especially when he can't own up to his errors. Especially one paid by the defense team, but this also should be mentioned. Douglas's mistaken belief that someone inside the sheriff's office was behind the Green River letters that allowed Gary Ridgway to continue to kill women for nearly a decade. In his book, Law and Disorder, he wrote the following fallacy about Damien, Jason, and Jessie. Damien and Jason had no indicative violence in their pasts, and while Jessie was known for a hot temper, he channeled his aggression into pursuits such as wrestling. He was also known to be very gentle with children and often babysat in the neighborhood. Though 3 were raised in a culture in which corporal punishment was common, none were abused. In sum, I found nothing in the behavioral backgrounds of the Damien Echols, Jason Baldwin, and Jessie Misskelley to suggest that any were guilty of murder. Now, if you listened to episode 3 of the West Memphis Three for Dummies and heard the highlights of Damien Echols' Exhibit 500, you know what Douglas wrote is pure bullshit. He either never read or knew of the mental health records, or he purposefully omitted them in favor of a narrative for the defense team who hired him for his services. Jessie Misskelley was known for fighting, including a couple of alleged violent acts against younger children reported in the months leading up to the crimes on May 5, 1993. As far as having been abused, Jason Baldwin, by his own account, was physically abused by his stepfather in his later childhood and as recently as a few weeks before the crimes. Damien had detailed an assortment of physical mistreatment by his own despised stepfather who also was accused of sexually abusing his sister. Now let's look a little bit more into Jessie Misskelley. 1986, 1987, reports from the book Blood of Innocence. Once stabbed a 4th grade classmate in the mouth with a pencil. Allegedly hit a girl in the head with a rock or brick during an altercation with her boyfriend. The girl fell down, couldn't get up, according to the complaint by the girl's mother. He gets so mad, he's capable of hurting someone. I don't think he can control it. He needs some help. That's from Jessie's stepmother, as quoted in a social worker report. 1992 police reports. He said that Jessie put a knife to his throat and threatened to kill him. He hit him at least once. Early 1993, per report. Struck a 6-year-old girl in the head with a rock and laughed, according to his friend Dennis Carter. March 1993, police report. Charged with punching 13-year-old Tiffany Allen in the face. May-June 1993, employer report. He whipped a grown man right out there the other day. If it hadn't been for Big Jessie stepping in to stop it, he would have been hurt. That man would have been hurt bad. And that's garage boss Jim McNeese. Now let's talk about Jason Baldwin for a moment. In the book Dark Spell, Jason talked openly about the physical abuse doled out to his mother and later on to himself and his younger brothers by his stepfather, Terry Grinnell Sr. And it all culminated in April 1993, mere weeks before the crimes, when 16-year-old Jason retaliated against his mother's abuser with a baseball bat and chased Grinnell from the home. Now, there's not much information about Jason being violent outside the report of a fight, after which it was noted that Damien licked the blood that had dripped from Jason's bloody nose. Additionally, one of Jason's school essays recounted an incident where he put his younger brother in a chokehold. And he claimed that he's usually a calm person and can take mostly anything, but sometimes when he gets angry, it's not a pretty sight. And he grabbed his brother, put him in a chokehold, and held him there till his face turned bright red, and then he let him go. And then he threatened, mess with me again, and it'll be worse. And you know, it's funny, it's amazing what those skinny arms can do to a younger child, right? The ones that the Paradise Lost filmmakers didn't think was possible. But it's clear to me, and it should be to you, that John Douglas custom-fitted a profile for Damien's defense the same way he custom-fitted a profile for Guy Paul Morin as the murdering rapist of Christine Jessup. November 21st, 2007. District Judge William Wilson issued an order in which he stated he planned to hold Echols' second amended petition in abeyance pending exhaustion of state court remedies. He further requested that Echols' attorneys file monthly status reports to inform the court of the status of the state court proceedings. November 26, 2007. A letter posted on the Dixie Chicks website and a December 19, 2007 Free the West Memphis Three rally. Natalie Pastar made remarks in the letters and at the rally. Pastar all but accused Terry Hobbs of murdering Michael Moore, Christopher Byers, and his stepson, Stevie Branch, in the Robin Hood Hills area of West Memphis, Arkansas on May 5, 1993. January 29, 2008. Judge David Burnett wrote a letter to all counsel of record stating that he has set aside the last 3 weeks in April 2008 to hear the pending motions in all 3 cases. February 21st, 2008. All parties submit a joint status and case management memorandum to inform the court that for a variety of reasons they cannot begin a multi-week evidentiary hearing on April 14, 2008. March 28, 2008. Judge David Burnett wrote a letter to all counsel of record stating that he has set aside April 15th for a hearing on all matters in all 3 cases. April 11th, 2008. Attorneys for Echols filed a motion for a new trial. April 15th, 2008. Hearing in Jonesboro. Judge Burnett told the attorneys that he wants all motions filed by May 30th and the state to respond by July 15th. He set an August 20th hearing for attorneys to give him a status report. After looking at schedules, Burnett scheduled hearings beginning September 8th through October 3rd to hear the appeals. Each defendant will have 1 week. Burnett also issued a gag order, telling attorneys on both sides that any contact with media was forbidden. May 29th, 2008. Attorneys for Baldwin filed amended Rule 37 petition. They also filed a writ of error, coram nobis, with the Arkansas Supreme Court, claiming prosecutors withheld evidence from Baldwin's trial attorneys. May 30th, 2008. Attorneys for Baldwin filed a petition for writ of habeas corpus and motion for new trial. June 5th, 2008. Attorneys for Misskelley filed a petition for writ of habeas corpus and motion for new trial, as well as an amended Rule 37 petition. Additionally, they also filed a writ of error coram nobis with the Arkansas Supreme Court. June 26, 2008. Without comment, the Arkansas Supreme Court denied Baldwin's and Misskelley's petitions to reinvest the circuit court with jurisdiction to consider their petitions for writ of error coram nobis. The petitions are denied without prejudice, which allowed the defense to renew the requests later. August 20th, 2008. Status hearing in Jonesboro. Judge Burnett tentatively scheduled a September 8th hearing to conduct an Act 1780 hearing for Echols first, then a hearing for Baldwin and Misskelley if needed. However, he said he could follow the prosecutor's suggestion that the DNA evidence offered by defense attorneys isn't sufficient to order a new trial or overturn the convictions of either defendant, and that he could rule in chambers before September 8th and forego a hearing. Burnett also said he could begin hearings for Misskelley and Baldwin on September 8th to determine if they received ineffective legal counsel at their trials. He also denied the defense's request to have him recuse himself from the case. September 10th, 2008. Judge Burnett issued orders denying without an evidentiary hearing Echols' April 11th motion for a new trial, Baldwin's May 30th petition for writ of habeas corpus and motion for new trial, Misskelley's June 5th petition for writ of habeas corpus and motion for new trial. September 11th, 2008. Judge Burnett issued a letter stating that hearings for motions for post-conviction relief pursued by Baldwin and Misskelley on grounds not available to Echols is scheduled to be conducted from September 24th through September 30th. September 24th, 2008. Jason Baldwin's Rule 37 began in Jonesboro. District Judge William Wilson issued an order stating that he recused himself from Echols' case due to the fact that some of the principals in this case are long-term acquaintances and friends of his. November 4th, 2008. Brent Davis was elected to the bench. Craighead County Deputy Prosecutor Mike Walden will serve out Davis's 2 remaining years as prosecutor. November 25th, 2008. Terry Hobbs filed a defamation lawsuit against Natalie Pastar and the Dixie Chicks. The famous singer's letters seeking donations for the trio's legal defense fund mentioned a DNA test that found a hair belonging to Hobbs on a shoelace used to bind one of the murdered boys. Natalie wrote, "I am confident that you will see the DNA evidence is irrefutable and that these 3 men did not get the kind of trial that is promised to us as Americans." An odd statement, since the West Memphis Three's own serologist expert, Thomas Fedor, called it weak evidence based on 2 points. 1, the hair can't be definitively matched to Terry. And 2, secondary transfer would explain the hair fragment. A far cry from irrefutable, but this claim against Terry Hobbs is echoed to this very day, showing what kind of power the West Memphis Three publicity team really had. Terry Hobbs' lawsuit against Pastar's letter, when taken as a whole, accused Hobbs of committing the murder of Stevie Branch, Christopher Byers, and Michael Moore. Unknowns to Terry, Pastar's legal team would use this opportunity by deposing him about the Robin Hood Hills murders and shed light on his other unsavory situations not related to the case at all. September 16th, 2009. Deborah Moyer and her two daughters, Jamie Clark Ballard and Brandy Clark Williams, claimed in an affidavit to have observed Terry Hobbs calling Stevie back to the Hobbs family residence at approximately 6:30 p.m. on May 5th, 1993. It was also claimed that Amanda was playing in the Hobbs driveway. The family did not make a statement to police immediately following the murders, claiming they did not feel the information was pertinent to the case. These statements have been submitted as part of an actual innocence defense on part of Damien Echols. However, there are significant issues with these accounts. As shown in part 1 of the series, multiple accounts have Michael, Stevie, and Christopher headed north towards Robin Hood Hills or near it. Terry lived south of the crime scene. But let's recap. 6 o'clock p.m. or possibly earlier, Dana Moore saw the three boys on two bikes on North 14th Street. 5:45 to 6 o'clock p.m., the Baileys report seeing Stevie and Michael on W.E. Cat. Michael told Otto Bailey that he was in a hurry and needed to leave. The boys are going toward Mayfair. Also around the same time of 5:45 to 6 o'clock p.m., Deborah Oettinger says the boys met up in her yard and eventually go into the woods via Goodwin. 6 to 6:30 p.m., all three boys are seen by Cindy Rico. She said she saw them by the drainage ditch, down past Blue Beacon, down by the bridge. 6:45 p.m., Brian Woody said that he saw four boys playing on Goodwin, not confirmed as Stevie, Michael, and Chris, but this possibly showed they were going in and out of the area, but not straying far from Robin Hood Hills. All evidence points to Stevie, Michael, and Christopher being north at the time of Deborah Moyer, Jamie Clark Ballard, and Brandy Clark Williams' claim, which would have had the boys south of where multiple others spotted them. Not to mention, Amanda wasn't with Terry, but at the Jacoby residence. Based on this, Stevie, Michael, and Christopher and Amanda could not be at two different places at the same time. However, the West Memphis Three propaganda machine ran with these three women's accounts in a smear campaign against Terry Hobbs and to raise doubt of the guilt of the West Memphis Three. October 2nd, 2009. Testimony concluded in Baldwin and Misskelley's Rule 37 hearings. December 1st, 2009. Terry Hobbs lost his defamation lawsuit. U.S. District Judge Brian Miller dismissed the suit, saying Hobbs had voluntarily interjected himself into a public controversy over whether the three teenagers convicted of killing the three 8-year-old boys had been wrongfully condemned. Something to note in the ruling. Natalie's opinions have been shaped not by reading the facts of the case, but by watching the two Paradise Lost documentaries, lengthy correspondences with Lori Davis, and watching the Echols legal defense team's very biased press conference. This is typically how most of the celebrities have reached their conclusions, not based on sound evidence, but built on bias, relatability, or feelings. And allow me to share some examples. So, Eddie Vedder, this was an August 6, 2013 Facebook post, and he wrote, "I was never sure if Damien Echols was innocent until I asked him face to face. The answer he gave me and the unflinching trust that I could see from human to human, that was when I truly, truly believed." Okay, well, that's not how you base evidence of someone's guilt or innocence. I mean, they could be a very good manipulator. But anyways, let's move on. You have Johnny Depp. He became interested in the case after watching the first Paradise Lost documentary, and he stated, "Oh, I immediately related to Damien what he went through growing up. He came from a small town in Arkansas, and I came from a relatively small town in Kentucky. I can remember kind of being looked upon as a freak or different because I didn't dress like everybody else, so I can empathize with being judged by how you look. Punk rock musician Henry Rollins saw himself in Damien, and he stated in Rolling Stones back in 2011 that he found himself up at 3:30 a.m. thinking about Damien, that it could have been him, and that he had those records and he was a sullen teenager. And of course, that's not why Damien, Jason, or Jessie were arrested. Rollins also was ignorant about the case, and he claimed multiple times in interviews that Jessie wasn't read his rights. And if you go back to part 1 of West Memphis 3 for Dummies, you know that's factually inaccurate. Also, West Memphis 3 researcher Lisa O'Brien and others confronted Rollins of this issue in June 2003 behind the New Daisy Theater after he preached the West Memphis Three's innocence. Despite correcting Rollins that Jessie was in fact read his rights, the stubborn punk rocker refused to accept factual information because it didn't align with what he believed to be true. Lord of the Rings and Hobbit movie filmmaker Peter Jackson. Like the others, he got involved by watching the very biased Paradise Lost 1 and 2 and reading the internet, most likely websites like Free the West Memphis 3, and after that he became invested in the case and donated a shitload of money to the defense. He also donated money to Lori Davis through the Defense Fund in July of 2005 with a letter that said, "Let us know if there's anything we can do to help from New Zealand." And Lori would correspond with Peter and his wife on a regular basis after that. Let this be a lesson. Celebrity endorsement is powerful, but they don't know shit about criminal cases other than what is spoon-fed to them. January 20th, 2010. Judge Burnett denied Baldwin's and Misskelley's Rule 37 petitions. May 18th, 2010. Judge David Burnett won in the Democratic primary for the state's 15th Senate District. Burnett won in the general election running unopposed. September 30th, 2010. The Arkansas Supreme Court heard oral arguments in Echols' appeal. November 4th, 2010. The Arkansas Supreme Court reversed Judge Burnett's September 10th, 2008 orders and remands the defendants' cases back to the Circuit Court for evidentiary hearings to consider new DNA evidence and a charge of juror misconduct. November 30th, 2010. Circuit Court Judge David Laser is appointed to preside over the evidentiary hearings ordered by the Arkansas Supreme Court. He replaced retired Judge David Burnett, who presided over the original trials and all hearings, because Burnett has been elected to the state Senate. January 2011. Scott Ellington became district prosecuting attorney, replacing Brent Davis, who became a judge, and Mike Walden, who was appointed to fill out Davis's term. January 4th, 2011. Scheduling conference in Circuit Court in Jonesboro. Judge David Laser ordered all parties to file briefs with him by February 18th regarding issues to be addressed at the evidentiary hearing. Laser also decided that a single hearing will be held for all three defendants, which would save time and money for defense attorneys. He also ordered a gag order in the case, prohibiting attorneys from talking about the case with the media. February 18th, 2011. All parties filed pre-hearing briefs as ordered by Judge Laser. Additionally, attorneys for Baldwin and Misskelley filed their respective Rule 37 briefs with the Arkansas Supreme Court. March 15th, 2011. Damien Echols filed a motion for additional DNA testing and other forensic testing. March 17, 2011. Judge Laser issued an order stating that the evidentiary hearing was scheduled for December 5, 2011 through December 21, 2011. April 8, 2011. Damien Echols' motion for additional DNA testing and other forensic testing was approved. April 18, 2011. Judge Laser issued an order authorizing and directing additional DNA and other scientific testing as requested by the defendants. May 5, 2011. The state filed briefs in the Baldwin Misskelley Rule 37 appeal. May 19, 2011. Attorneys for Baldwin filed their Rule 37 reply brief with the Arkansas Supreme Court. May 24, 2011. Attorneys for Misskelley filed their Rule 37 reply brief with the Arkansas Supreme Court. August 18, 2011. Judge Laser issued a notice which stated that the court will take up certain matters pertaining to the case of defendants Baldwin, Echols, and Misskelley on Friday, August 19, 2011. One session will be conducted out of public presence with all defendants present, and another session will be conducted in open court. The session conducted in chambers will likely begin at 10 a.m., followed by a public session which will begin about 11 a.m. August 19, 2011. Hearing before Judge Laser. It is announced that as the result of negotiations between prosecutors and defense counsel to resolve the cases, Judge Laser vacated the convictions on the condition that the defendants enter guilty pleas pursuant to the U.S. Supreme Court case known as North Carolina v. Alford. Echols, Baldwin, and Misskelley entered Alford pleas, which meant they pled guilty but do not admit to the act and are allowed to maintain their innocence while at the same time acknowledging that the prosecutors had enough evidence to convict them. In accordance with the plea negotiations, Judge Laser sentenced all three to time served, followed by a 10-year term of suspended imposition of sentence. If they reoffended, they can be sent back to prison for 21 years.
What it all came down to for me was we knew we would win this eventually. We would be exonerated eventually. The state knew that. But they presented this deal to us, basically saying, you can sign this paperwork and you can walk out of prison this week. You can go home before this week is out. Or you can refuse this deal and yeah, you'll eventually win, but we'll drag this out for another 5, 10 years, however long it takes. You know, Scott Ellington also says in the movie, the prosecutor, that one of the considerations they had in offering, in agreeing to this deal, was that the three of us together could have effectively sued the state for $60 million. So you take that in consideration with the fact that I also knew how corrupt and how desperate they were, and I knew they could have had me stabbed to death in that prison any day of the week for $50.
Damien Echols, as always, lied about the circumstances. The state didn't offer this deal, the defense did. This deal originated after lab results ordered on April 18th came back to the defense team, and it revealed nothing of value for their clients. These lab results have never been made public. This prompted one of Damien's attorneys, Patrick Banka, to meet with his old law school buddy, Arkansas Attorney General Dustin McDaniel. The two would later go on to be partners in a law firm called McDaniel, Wolf, and Banka. Banka offered a solution that would satisfy all parties. It was the brainchild of Stephen Braga, who was also representing the West Memphis Three. This idea was presented to Scott Ellington, and he was agreeable to it as long as all three offenders pled to it. If not, no deal. You know, Ellington didn't have intimate knowledge of this case. the way that Brent Davis did. He ultimately wanted it to be over despite the protest from Todd Moore, Dana Moore, Stevie Branch Sr., and Terry Hobbs. If need be, they were willing to see this go back to trial. Instead of waiting until the evidentiary hearing to see how things would play out, Ellington, like a newbie prosecutor, fell for the defense's poker bluff, and just like that, the West Memphis Three were freed. But, at least as convicted child killers on probation. Even some of the reasons for Ellington to go along with this deal didn't make sense. One being jury misconduct. He claimed he believed that the allegation of misconduct on behalf of a juror in the Echols-Baldwin trial would have likely resulted in a new trial ordered. But would it have, really? So the story goes, Kent Arnold, the jury foreman, wanted to put Damien behind bars badly and introduced outside evidence in deliberation like Jessie's confession, which wasn't permitted in Damien and Jason's trial. However, it wasn't Kent who introduced it to his fellow jury members, but Damien's lawyer Val Price. It accidentally came about while grilling Detective Brian Ridge. For years, they tried spinning this into an appeals claim in one form or another, and it failed each time. Now, in a notepad, Jessie's confession for side of guilt during deliberation was written, but scratched out as something that couldn't be considered. But Kent Arnold didn't bring this forward to an unknowing jury. Also, an attorney named Lloyd Warford came forward and claimed that Kent Arnold told him this whole thing, but of course, like an honest man, he decided to wait 16 years to come forth with this alleged information. If Warford knew that this was improper, he did absolutely nothing about it, again, for 16 years. He never reported it, but he sure waited for a convenient time to make the allegation, so I don't find his statements about Kent Arnold credible, and neither should you. In a commercial appeal article, Echols' original defense attorney, he took this whole thing in. Among bystanders outside the courthouse was Val Price, and as a testament to changed times, Price, who in 1994 defended the Mid-South's most notorious teen murderer defendant, said he's now a juvenile prosecutor. Watching the carnival atmosphere around him, he just smiled and shook his head. When asked if he believed Damien Echols was indeed innocent, Val Price squinted his eyes and shook his head again. It's hard to say. Think about that. That's his own original defense attorney. August 24th, 2011. Attorneys for Misskelley filed a motion to dismiss the Rule 37 appeal that was pending before the Arkansas Supreme Court. September 8th, 2011. The Arkansas Supreme Court granted Misskelley's motion to dismiss the Rule 37 appeal. Attorneys for Echols filed a motion to dismiss his federal habeas corpus petition. September 28, 2011, District Judge Brian Miller issued an order granting Echols' motion to dismiss his habeas corpus petition. So I was originally going to end the episode there, but there was just this part of me that didn't want to do that. So I want to end it from a Jonesboro Sun article that came out December 3rd, 2011. Victim's father still feels pain. The last moments Todd Moore spent with his son Michael remain vivid in his mind even after 18 years. Father and son played in the backyard of their West Memphis home with the family's yellow Labrador, Smiley. Soon they ventured inside to watch television. Todd had to run a trucking route in southern Louisiana a few hours later, and he needed to get some sleep. "Love you, son," he said to 8-year-old Michael. "Love you, Dad," the boy replied. It was May 4th, 1993. Those were the last words ever spoken between them. The next day, Michael and two playmates, Stevie Branch and Christopher Byers, were abducted and murdered. Their bodies were found in a West Memphis area creek the next day, not far from their homes. There is not a day that goes by that I do not think of him, 47-year-old Todd told The Sun in a rare public interview. I love my son dearly, and I miss him every day. The gruesome murders drew nationwide attention, and within a month, 3 Marion teenagers, Damien Echols, Jason Baldwin, and Jessie Misskelley Jr., were charged in the killings. Less than a year later, all 3 were convicted, and Todd said he and his wife Dana tried to pick up the pieces of their lives. While the parents of other victims, supporters of the accused, attorneys, and others fought the case out in numerous court hearings and in the media, the Moores shied from the limelight. In August, Todd got a call from Crittenden County Sheriff Mike Allen, the man who found Michael in the creek. He told him to come to the sheriff's department to meet with prosecuting attorney Scott Ellington. When Todd arrived, he got stunning news. To his dismay, he was told Echols, Baldwin, and Misskelley were to be released August 19th after a plea deal had been worked out with the defense attorneys and the prosecutors, ending one of the most controversial legal cases in Arkansas history. I expressed my opinion and was basically told it was the prosecutor's decision and he was moving forward with it, and the parents basically had no say in the decision, Todd said. That angered me, and I sent him an email later that day to express my feelings. He has yet to respond. Ellington said he received an email on August 15th, and he didn't think from the tenor of the communication a response was desired. If I was in his shoes, I probably wouldn't have liked it either. I feel bad for him and his family. I hate it. This is really sad, Ellington said. Watching the men walk free was gut-wrenching, Todd said. Another part of the case that angered Todd is that it's not certain that the so-called West Memphis Three are employed or in school. Conditions of probation. I'm tired of seeing these convicted killers on New Zealand ski lifts and partying in Amsterdam, Todd said. They lack any discernible employment or enrollment in school. Numerous stories have them jet-setting around the world. The 3 men have unsupervised probation, and determining whether they are employed would be difficult, Ellington said. But with a weak economy, it's unlikely a judge would return the men to jail if they were unable to find a job, he said. Baldwin may be working a construction job in Washington state, and Misskelley's perceived mental problems may prevent him from getting a job, Ellington said. Echols is reportedly in New Zealand. We welcome Echols to stay in New Zealand, whether he's working or not, Ellington said. Todd said he doesn't believe new DNA and forensic evidence is enough to exonerate the men. A series of confessions by Misskelley is the most compelling evidence against them, Todd said. Since the 3 were freed, Todd said he's seen Echols and Baldwin on television and even had a chance encounter with Misskelley at the post office. At first, he didn't realize it was him. But then he knew. I saw one of the killers in the street, Todd said. My heart dropped, and I felt ill for the rest of the week. Misskelley left before the men confronted each other. Todd and Dana divorced in 2005, but the two have a cordial relationship, he said. They have considered possible legal action in the case, but are not pursuing any type of litigation at this time. Michael's parents recently petitioned the Academy Awards not to consider Paradise Lost 3: Perjury, a documentary about the case, for an Oscar. It's the third film by Joe Berlinger and Bruce Sonitsky about the case. The Moores claim that they were deceived by the filmmakers, a claim the directors have denied. Todd said the first film in which they appeared was a manipulative and deceptive effort by the directors. Berlinger told The Sun earlier this week the film was originally conceived as a way to document how the three men could have committed this heinous crime, but as filming commenced, the directors became convinced the West Memphis Three were innocent. Beyond the chaos surrounding the case and the scrutiny of the national media, Todd said he takes time each day to think about his son, a Cub Scout who loved the military. His love for military things would lead me to believe that he would have followed in his dad's footsteps and joined either the U.S. Navy or U.S. Marines and proudly serve his country, Todd said. There's not a day that goes by that I don't think of him. That's all for today. I know that it was a lot of information. It was the longest episode in the series, but if you stuck around to the end, thank you. I hope you learned something. There will be a part 5, but until then, I'm Rick. This is Burn After Reading, and I'll catch you next time.
Burn the lies, burn the fear inside myself, and burn it all again. To right time to escape these gates I've been looking